I would like to say, in terms of the document production, the tribunal has very wide discretion to make the decision as to what documents should be provided and what can be prevented from being disclosed. So what is important for the parties to consider is, firstly, you have to know what is the document production rule, and secondly, you'd better comply with these rules.
It's quite hard, as I hope I've demonstrated, to really precisely define what mediation is and what mediation is not. It might be easier to start by thinking about the objectives of mediation. And there can be quite different purposes or objectives or goals for mediating, depending on the perspective you take. So from the court's perspective, service delivery is often a major objective, and that means getting people access to a resolution swiftly and inexpensively. All right, so rather than waiting a long time for a day in court and that costing a lot of money, that you can have a cost-effective and quick, relatively painless solution outcome for your dispute.
As I have mentioned, tribunal-ordered interim relief is dealt with briefly in Article 17 of the 1984 Model Law. The 2006 amendment substantially expands Article 17, adding a further 10 provisions to this article. These additions include providing a definition for interim relief, setting up a test to be applied for interim relief, providing for preliminary orders.